Welcome to Margin of Thought, where we make space for the questions that matter. I'm your host, Preeton, and together we'll explore questions that help us preserve what matters while navigating what's coming. For this episode, I get to talk to Tiffany Brown, litigation counsel at Tech Justice Law, where she focuses on AI chatbot liability. She also leads skillless education, supporting students and families through tutoring and special education advocacy. Before that, she worked in government at the U.S. Department of Justice's Civil Rights Division. Tiffany and I have already chatted twice on her own podcast, and so I'm excited to have her here today on mine. Our conversation today asks what accountability should look like when AI products cause real harm and what safeguards need to exist before people get hurt. Let's get going.
So I am currently with Tech Justice Law full-time as a litigation counsel, where I focus on lots of different things, but mainly AI chatbot liability more recently. And I have also, in a part-time capacity over the last 15 years, I would say, or maybe even more, I've owned and operated an educational consulting firm that basically provides lots of different avenues for academic support, including tutoring that supports students, but also special education advocacy that supports students as well as their families. And then a little bit of policy work goes into that as well. And then prior to joining Tech Justice Law as a litigation counsel, I had various roles in the government doing a lot of policy work, most recently related to civil rights at the U.S. Department of Justice Civil Rights Division, which of course touches on education and all things disability rights. And then prior to that, health and human services and a few other roles. But yeah, that's me in a nutshell currently.
You're tackling these problems from a lot of different angles, and I want to talk about some of the overlap between them, if any. I really want to hear about the kinds of cases that you're working on, but maybe we can start with what kinds of things were you litigating prior to the AI chatbots?
So interesting. I actually went to law school later on in life. So I am not a baby lawyer anymore, I don't think, but I graduated in 2020. And so most of my work has been policy work, policy related. Um, Prior to joining Tech Justice Law, I did lead the AI and Civil Rights Working Group. I should say co-led the AI and Civil Rights Working Group. I helped out a lot with developing and pushing the AI and Civil Rights Working Group forward, which was kind of like my entree into the tech world. But I was doing policy work. But in that capacity, I helped to kind of think about litigation strategy, which really made me want to do litigation. Policy work is a very important lever, but it was really that role at DOJ that made me really want to focus on litigation. And so while I was at DOJ, we didn't necessarily bring a number of cases in the tech space. It was a lot of background work as far as learning what sorts of technology is out there and what are the emerging concerns from a civil rights perspective. And if we were to bring cases, if we were to enforce, what would be our legal strategy and what would be the evidence that we would need and who would be our partners and all sorts of questions. And so there was a lot of, I think, build up and research and laying a lot of the groundwork for enforcement. And so being litigation counsel currently at Tech Justice Law, this is actually my first role kind of doing solely litigation.
So that's like jumping into the deep end. It feels like with how quickly things are moving, but also how complicated things are because there's no case law and precedent on it, or basically non-existent.
Right.
So what sorts of challenges are you all working on to help navigate these problems?
So Tech Justice Law is a fairly new organization. It's only been around for more than a couple of years, but the types of cases, and I think where the expertise has developed over the last couple of years is in AI chatbot liability. And so we filed a number of cases, even recently, relating to harms that have been brought on in connection with OpenAI's ChatGPT. And so there were a number of cases filed in November of 2025. And just recently, there has been what's called a JCCP that has been formed because there have been lots of other cases similar to ours that have been filed. And there's going to be kind of like this group effort from the perspective of the court to litigate these cases. And so they're product liability cases at their core. And what they have to do with ChatGPT, essentially being a defective product and interacting with consumers in a way that is extremely harmful. Um, and we've gotten a slew of these cases, unfortunately. And so that has kind of been our bread and butter. There are other cases that we are part of or pursuing, but those have been the cases that have gotten a lot of attention in the last 6 months, of course. And that's where we've spent a lot of our time recently.
Well, I have lots of questions because there's so many different ways we can take this, but I want to start with, can you help us understand the larger space right now in terms of holding maybe like the AI companies, but also any tech companies responsible for their products? Because I know we had some movement on the social media front this year, and I'm wondering if that is promising and if any of that applies to the kind of work that you all are doing.
Yeah, it's definitely, I would say, promising. I do want to point out, and you've already said this at the beginning, AI and AI powered products are fundamentally different from social media products. And so it brings up a whole different category of things to consider. There's, of course, similarities. And again, I would say that the movement in the social media cases are helpful. And it's also really welcoming to see accountability after so many years of seeing some of the harms that have come from these social media platforms. But AI is just moving so fast. So even when I started at the DOJ and was in the AI and civil rights working group, I don't even think we were contemplating, specific harms from generative AI products because it was very new. I mean, ChatGPT debuted in 2022. And so we're still talking about products and that was just the early iteration. So we're still talking about products that are just so new. Everyone's trying to wrap their heads around how they work and the harms that they potentially cause. But I do think that movement, again, in the social media cases is promising. And even the fact that our cases are even making it as far as the complaint stage and even further than the complaint stage. And, that there's movement here as well in the chatbot liability cases is also promising. I think it's kind of a nod to the fact that the public is now paying attention to AI in various sectors and not just, in the way that we use AI as productivity tools, but also how we're using AI in education and how we're using AI even in healthcare. I think the public is now starting to pay attention because these cases have brought these potential harms to light, which is really important. And the courts, I think, are also taking notice.
I am glad that we're seeing movement much faster than I think we did with social media platforms. That to me is promising, at least. I want to kind of dig into a little bit about like what sorts of harms are making it to the courts. And so I know you mentioned that part of it's like treating them as defective products, but is this like the kinds of different harms that I'm thinking about are everything from like bias and racial profiling to like the mental health implications of it, to maybe something as simple as like the hallucinations as a defect of the product. So is that the kind of things that you're talking about when you mention that, or are there pieces of this beyond that?
Yeah, so we are definitely tracking all of those sorts of harms and cases. There's a wide array, unfortunately. So our lawsuits, unfortunately, deal with sometimes minors who, have gone to ChatGPT on advice about committing suicide, and they have succeeded in committing suicide, unfortunately. There have been suicide attempts due to what are referred to as AI delusions. And this is not the clinically appropriate word, but the media has kind of taken it and run with it. But AI psychosis that kind of leads down rabbit holes where you might start out talking or conversing in a way, or I should say, exchanging interactions, because we don't want to humanize the product at all. But um, having interactions with ChatGPT that seem pretty innocent. You might ask, what temperature should I bake a chicken? Or like, what are some ways that I can improve study habits? Like really innocent things that you start to use it more. And then all of a sudden you're asking it about relationship advice. And then all of a sudden you have this emotional attachment, or you start asking advice about more personal things. And you go down a rabbit hole of these interchanges that all of a sudden are now harmful. And so we've had those sorts of situations where people kind of go down an AI delusional sort of spiral, if you describe it that way. And then there's other harms, as we've seen more recently in the courts. Um, the school shooting that occurred in Canada, there are now a few suits that pin ChatGPT as this contributing factor to those shootings because the person um, helped use ChatGPT to help them actually plan out the shooting. And so that's really grave harms. But then you also think about harms just like outside of those, as far as like the unauthorized practice of law, for instance. There is now a suit looking into how ChatGPT, things like ChatGPT has participated in the unauthorized practice of law. So giving people legal advice and it not, working out so well. Those are not obviously as serious as suicide and attempted suicide and shootings where there are fatalities, but it's also a harm. There's also a slew of other harms that, we're tracking as far as like inappropriate child sexual abuse material, and even with ads coming to generative AI products, as we've seen in the news, that opens up a potential for various harms. And so there's a lot of movement. There are a lot of things happening in this space. And even though our lawsuits have kind of focused on a bit of a niche sector within the landscape, we're tracking all of it because it all kind of relates to a deeper core issue of what should we be using these products for? They are helpful in some ways, but in other ways, it should just kind of be off limits, in my opinion. And so, kind of trying to draw that line of what makes sense here. Like, should we be using chatbots for companionship? Should we be using it in the healthcare field? And in what way? What specific ways? Should we allow it in schools, and in what way? So I'm not saying get rid of it all. I'm just, kind of bringing light to, I guess, raising the flag that we got to be careful about how these products and how AI, and specifically general purpose LLMs, are being marketed and rolled out to the public without safeguards and without critical guardrails that will prevent harms, whether it's suicide, whether it's shootings, whether it's legal advice, medical advice, financial advice. Like there just has to be more thought put into what we're doing here.
I want to understand what resources our legal system provides for these kinds of cases. And so, like I think that a lot of folks might agree that we should be cautious about those different use cases. So it's like, if your friend was using it as a companion or using it for like as a therapist, maybe we might step in and help them reason through why that's not a great idea, alternatives, right? I'm trying to think of other examples of when, and again, like this is new space, but other examples of when the law has been able to kind of assign that sort of liability to the company itself and what might provide us those opportunities with AI. And so, like, and maybe an example of what I'm thinking about might help when you're thinking about the student or child who's chatting with the chatbot and it ends up leading to the cycle of worsening the mental health crisis. That a scenario versus a child that's reading a book that also leads them down a similar mental health crisis, right? Why should we and why can we hold the AI company or hopefully can hold the AI company responsible, but not the author of the book, maybe, or the publisher?
Yeah. So I would answer that by first giving a very lawyerly answer, and all the lawyers will agree with me and know what I mean. It depends on the facts of the case, like the intricate facts of the case to make a determination. However, I think it's all about foreseeability, right? Can you foresee certain harms with this sort of product or technology? I don't know that people would say, oh, this book, that's going to drive someone down to give them a mental health episode. Or, I don't know if that there's that foreseeability there, as in with other products, especially products that are mimicking human behavior and human emotions and, other sorts of almost manipulative design a bit. There's some foreseeability there, right? Like you could see, oh, this might not be great for a 12-year-old to be talking to a chatbot that is pretending to be human. Particularly if there was some research done behind the scenes, right? If you have an autonomous car powered by AI, there are some harms that are foreseeable, and the manufacturer of that car has to take those um, into account. And so that's the first thing I'd say. But then also with product liability, sometimes we don't even need to meet that threshold. If you put out a defective product, you're unfortunately if there is enough there to say, yeah, this is bad, like this is harmful, and look at this connection, you're going to be liable. So there's strict liability in that sense. And then there's also what I was just referring to as negligence. Like, you guys were negligent in, rolling this out because you didn't consider all of these certain potential harms or what could possibly happen when you should have known. Um,
Yeah.
so there's different avenues. Unfortunately, again, this is all very new. So we'll see how it all plays out, especially in the tech space. But you can kind of think of, I know that with the social media cases, they have been compared to the tobacco cases of the 90s and early 2000s, where those companies were, held accountable for marketing their products to young people and being very deceptive about the harms and how addictive cigarettes can be. And so that was, it's the social media is having its big tobacco moment. We'll see what happens with the sorts of cases that are coming up now. But yeah, I think I find the work interesting because of like digging into this product liability doctrine a bit. And to go back to also your point about other types of harms like bias and all of that is still yet to be uncovered as well. And there's certain cases like civil rights cases and disability rights cases specifically that are making it through the courts. Some of it is publicly available, some of it is a little bit harder to get, but we are in a time where in 2 or 3 more years, we might have more clarity around what these legal doctrines and legal theories, um, like whether they'll win, whether they will actually like prove successful in court or not. But I think, again, in about 5 years, we'll have more data around, what does product liability doctrine look like in terms of generative AI products, or what does it look like with other types of emerging technologies? And then we haven't even talked about things like agentic AI and what's coming. And so what would liability look like there as well? So we'll see.
How many of the product liability cases that you've seen or that you're working on are reliant on the end user being a child? Because that I find interesting that we like, right, like big tobacco predominantly ended up being about marketing to minors. Similarly to social media, it's about how manipulative and addictive the technology is for children. But obviously these harms are not limited to children. And that's true of like there's cases of adults who died by suicide after talking to AI chatbots. So what role is the end user like demographic playing in how likely or how strong these cases are?
That's a great question and something that we talk about all the time. But the truth is that we're getting cases that are all sorts of demographics. It's like it's not affecting just young people. It's not affecting just older people. It's interesting, and we'll have more data as we have more cases that come up that we're able to kind of recognize trends from what we're seeing now. We have young kids that are impacted, and then we have vulnerable populations like people with disabilities being impacted, women, men, all sorts of ages, which has been very interesting to see, I think. But you're right. There's this younger person element to teenagers and young adults, to the social media cases, and even the cases that have been filed so far. But again, there's a good mix of types of people and honestly types of harms that all kind of have that same thematic, you know, product liability argument. But I think it's an interesting point, and just maybe one other important key difference about how AI powered products like generative AI products and other general purpose LLMs, it's different from social media, even though there are obviously similarities. But it's just the magnitude and the speed at which it's impacting not only a certain segment of the population, but all sorts of different type of people, and also like different areas of the world, different areas of the country, different walks of life, from socioeconomic status to, I mean, it's just all over. And even I would say, interestingly, people who appear to be tech savvy, right? Which is also an interesting point. Like people who are pretty familiar with how the tech works, or at least on the surface, all the way down to people who are not as tech savvy. So it's just a variety, which has really been interesting to see.
I feel like one of the international stereotypes of American product liability are that you can just disclaimer your way out of everything. And so you see that, well, obviously, like every single chat interface has this, like, this is a chatbot and we're testing it and it will likely hallucinate. And I think the other day someone pointed out that the Copilot terms and conditions for even like their enterprise clients inside it says, oh, this is for entertainment purposes only, which is super interesting when they're pitching it to big companies and schools. Is that really enough to avoid some of the concerns about people using it in high stakes scenarios? And
Exactly.
the product is defective, right? Like it's making mistakes, it's making up case law, it's suggesting the wrong diagnosis, whatever it might be. But is it enough for the little warning? Is that them trying their best, or are those cases harder in practice as well?
I would say we would definitely argue that no, of course, that is not enough. You cannot disclaim your way out of this one. Um, especially like when there's high stake. I mean, we are talking about people losing their lives. And so that is the highest stake. And you can't just say, oh, we just checked this box. We checked this box. The question is, was it enough? Did you do enough? Were there other things that you could have done feasibly that would have made a difference here? And so even if you have disclaimers, there's still a way to hold companies accountable or liable for defective products. It's like I just used car examples. You can sell them a limit of a car and say, sometimes I'm just going to give you a warning. Like sometimes this car doesn't work, but that doesn't completely get you out of the woods if the car just completely falls apart on the highway, especially if you maybe have marketed that product as safe and reliable and trusted and all of these different things. It's like, so what are you saying about your product and what's actually happening? Is there a discrepancy? And then again, even there's still you have strict liability. So sometimes it's like if you did it, if you put out an effective product, it is what it is. There has to be some accountability.
When we think about how to approach these potential harms from the AI technologies, there's both sides of this. There's the proactive side of putting out regulations and policies, and we're using protective forces that way. And then there's the reactive one of these product liability cases. It seems like most of the work, partially partly because of how our legal system is structured, is happening at that reactive level in order to basically scare the companies into avoiding these cases. Is that unique to tech products, or is that basically how these kind of legal cases about product liability work in general?
Yeah, unfortunately, I feel like sometimes there has to be some sort of incident or something bad has to happen for there to be movement. And in some cases, even still, there's bad things that happen and then there's still no movement. But, I feel like unfortunately, the way both our Congress works and our legal system work, like all of the different branches of government work, things are just immensely slow. And sometimes it takes like something happening, unfortunately, again, for there to be movement. So we've seen in this area where there has been state movement with certain legislation at the state level being passed and also being proposed in state legislatures where the federal government hasn't acted. As far as the courts, right now it seems like litigation has been a bit more impactful um, at this stage of the game than the policy levers that we're used to seeing play out in Congress and then also at the state level. But I will say that litigation and policy work hand in hand, like they go together in a way. Where you have policy efforts happening, litigation might be playing a role in informing those policy efforts and vice versa. And so with my current job and even with a lot of my previous jobs, we're watching the courts and we're watching the legislatures and we're watching Congress. We're watching all of it because all of it kind of plays into how much progress is actually made and how fast. But I will say there has been a lot of movement at the state level, even the state enforcement agencies. where federal government has not acted quickly enough, I guess. So that's really, I think, encouraging to see that state AG's offices are opening investigations and they're filing suits and they're doing a lot of work and research into these issues. And because we're just not, I don't think we're going to see it in the next 2 or 3 years at the federal level.
I know I've started to see Meta is considering not offering their products in New Mexico, I believe, because of new like state level regulations that are coming out. And I mean, they can afford to do that when it's New Mexico, but New York is also working on, I believe, some like child protection regulations. I know California has been working really hard at it. So it is interesting to see how, even though it's like particular states acting, at some point it's easier to like I think that applies to a lot of the California online protection policies as well. Even if you're not a California company, I know there's revenue thresholds, but still there's pressure to basically offer that same protection to the whole country because you're going to have to offer it for California anyways. And so that to me is also a very fascinating quirk of our legal system. I wanted to talk a little bit more about the civil rights work and policies and see if the thing I'm wondering about in particular is there's obviously particular harms that the technology does. And maybe we can think about bias and depending on who the actor is, right? Like our legal system offers different options. And so I'm wondering the difference between, for example, somebody using a private chatbot going to ChatGPT maybe and asking for advice on who they should vote for. And maybe depending on the user profile, you notice that it's giving different answers or bringing up different issues to consider. Versus if tomorrow the federal government puts out a voter information bot and it's doing the same thing. My intuition is that we probably have very different resources in both of those cases. Is that accurate? And can you walk me through a little bit about what that looks like in each of those cases?
So, yeah, definitely different resources, different legal authorities as well. Different laws would apply, state laws versus federal government, federal law. So, there's lots to consider. There's one thing to be like a private plaintiff going to like a private plaintiff's firm that is way smaller than unless you go to like a big law firm and they have lots of resources. A lot of times these cases start out with small plaintiffs firms kind of coming together to try to bring an impactful case. And then on the other hand, you have the federal government, which has its own resource constraints, which is why things take a bit longer in the government, not only because of all of the different levels of red tape that you have to go through sometimes to bring investigations and enforcement actions. There are also limited resources, limited time, like not enough attorneys, not enough paralegals and legal support staff. And so there's definitely a difference there, just different types of resource constraints. But you are obviously able to kind of move a little faster outside of the government. I think you can talk to a client and want to bring a case, you can write up a complaint and file it the next day if you want to, whereas that is not the case with the federal government. But yeah, it's also going to depend on the laws. Like, do you have a private right of action? Can you actually sue whoever the defendant is as a private plaintiff? The federal government, sometimes you're looking for patterns and practices. You're not necessarily bringing a case on behalf of one person, but you're bringing the case on behalf of the American people and the public. And so you might be going after someone, a bad actor who has a pattern of practice of some sort of illicit activity or discrimination or whatever. So the approaches to litigation and enforcement are going to be much different. And I think from the private plaintiff side, you have to get a little scrappy with how you bring your cases because, a lot of times the federal government or even the state government for that matter, like state AG offices, they can demand things from companies that a little old private plaintiff plaintiff's law firm cannot just demand from a company. So there's just different authorities, legal authorities, and actual authority to be able to, not scare a defendant, but also, but it's like we're the government and we're asking for these things. You need to comply, sort of thing. Whereas a plaintiff's firm might have to get a little bit creative in how they get the evidence to even start writing a complaint to file. So that's also a major difference between those two scenarios.
I was wondering if when you think about the government vendor requirements and procurement policies, I was wondering if they might push the companies to have to deal with some of this in order to be able to work with a federal agency, just because obviously the government has different standards they have to meet themselves. But I know that's also very politically driven and depends on the administration and all of that, as we saw with the Anthropic OpenAI debacle, where that conversation about what each of them had to agree to would have been very different depending on who was in office. I'm sure that will vary. So you brought up agents earlier, and I want to think about that forward looking a little bit in terms of what other challenges we're gonna see. And I saw that a company yesterday is offering agent insurance to ensure, like, if a company has a bunch of agents working on their behalf, it's basically a liability insurance for the company against their agents' actions, which I thought was just fascinating and also scary in terms of where we're moving. There's this, like, the line I'm trying to figure out is, like, we don't want to treat agents as autonomous agents, right? Like, we want to hold the product companies responsible for the harms that it's causing. Um, but there's also a level of liability that is unique to agents because they can take action on behalf of someone without that person's consent, right? So like if I have an agent that's out in the wild and it like decides to commit fraud on my behalf, am I responsible or is ChatGPT responsible is an interesting. And I know we see this with self-driving cars as well, right? Like is the like owner of the car responsible versus is the car manufacturer responsible? Are we going to see a lot more of those? Because I feel like those cases seem interesting, especially as there's more and more autonomy given to the tools.
I want to say that it's a great point and a great question. And I want to say that there's been some movement, at least in California, on kind of like shooting that down. That, that there is like, just because you say that an agent did it doesn't mean that you're off the hook. And I forget what the name of the act is, but it just recently went into effect. And it's basically saying, like, you cannot put your, bad acting, whatever the thing is, onto the you can't say, "Oh, it wasn't us, it was our agent." And so we might see that sort of thing pop up in other states as well. And I think there's definitely probably ways around that. I think what companies, and I think this might be also what you were saying, companies are going to maybe bake in a certain level of cushion, like financial cushion, to be able to deal with or confront claims where their agents might act in a nefarious way or do something wrong. Um, but I definitely think that there's ways legally to get around that. And you can't just say, oh, the agent did it. So I'm just skeptical of those sorts of arguments.
When I saw the insurance company pop up, I was what the difference in terms of liability for companies of an employee going rogue and causing harm on behalf of the company versus an agent tool doing so. And I think what is going to be interesting is that the scaling of the harm is much higher, right? Like there's only a human employee who can, of course, liability concerns for you as a company, but like if you put up 200 agents and they all do something, right, the scale is so much higher. And that I think is going to create challenges, I think, for both, the companies themselves, but also I'm sure everybody in all the different sides of the equation there, because there's just so much that we have yet to figure out.
And even the inner workings of the actual technology, like we can understand a human doing things if we have enough videotape evidence or documents that we see, we can understand human behavior, but it adds a layer of complexity when you have systems acting autonomously and you're not able to actually pinpoint where did things go wrong. That's another layer, even from a litigation perspective. A challenge is uncovering the tech and lifting that black box to understand what is actually going on and how it's actually working, which is why, coming back to our original point at the beginning, is why safety guardrails and testing and rigorous training and testing before deploying it to a large amount of people at a massive scale is so important, not just to chase profit or to chase market share, because we have to really understand and think about the implications.
I can't think of a better note to end on. So thank you so much for sharing all of that. Like you said, I think over the next few years, we're going to see what direction a lot of this moves in, and hopefully that creates a momentum. If folks want to follow the kinds of work that you and your organization do, where can they check that out? And then tell us a little bit about how they can learn about the other work you do in the education space.
Yeah, so my firm, Tech Justice Law, you can reach us at techjusticelaw.org. And if you just Google us, all of our great work will pop up. And we just got a new website. So go check that out. It has all of our cases and all of our issue areas on there, as well as the contacts of all of the people who we work with. And then as far as my part-time Gillis Education passion project, it's been a passion of mine for, again, I've been doing it for over 15 years, but really something that started back when I was a teenager, mentoring and tutoring other kids. Of course, I am tracking what's going on in the AI and education space just because of the work that Gillis Education does. You can find us there at gilliseducation.com. And Gillis is spelled Gillis as in Sam.
Awesome. Thank you so much. And I'll add links to that in the show notes as well.
Yeah, well, thank you so much. This was a great conversation and great questions, as always.
Tiffany makes clear that AI accountability is a complex web shaped through courts, regulators, advocates, educators, and families. As AI systems become more interactive and autonomous, the legal system now has to confront new questions about harm, responsibility, and design. She tells us that companies need to build safeguards before these products actually reach people at scale, especially when users may rely on them during high stakes moments and when they're minors. For more on how we might shape these decisions, check out my book, Ethical EdTech, at ethicaledtech.org. Thanks for listening to Margin of Thought. If this episode gave you something to think about, subscribe, rate, and review us. Also, share it with someone who might be asking similar questions. You can find the show notes, transcripts, and my newsletter at preeton.org. Until next time, keep making space for the questions that matter.